All right, hey people, Russ Jensen. So here it is, first day of January 2017. Woohoo! Yeah, I made it through 2016. I'm not sure I'm going to make it through 2017, especially considering the fact what I'm currently doing right now, writing this book, building some websites, sharing information that is not very, well, it's certainly not winning me any friends, or going to be winning me any friends from the governmental organization, a criminal organization that runs this planet. Now, so, like I said, I'm writing a book, explains a lot more of these things in better detail than me just kind of rambling around, but these videos are important for me too. They help me kind of think, help me get information out, and they're good for people too to listen to. And I'm going to remake most of these once the book's finished, and go into more explanation, because the book, I'm trying to keep it simplified for people, and it really isn't very complicated what we're talking about, any of it. In fact, today I'm going to talk about how it is we can take some of these principles that we know for a fact we're using the government's own rules, regulations, their own laws against them. And, well, not against them, but utilizing them, applying those in a situation, and talking about the so-called federal prohibition on controlled substances of all kinds, 1, 2, 3, 4, 5, schedule 1, 2, 3, 4, 5, 6, whatever they are. Okay? And see if those really apply to us as individual members, lawful sovereign authorities of our societies operating out here in the states of the Union, where you all believe that you are living, and see if it really applies to you in that situation, or it applies in a more specific situation based on you being a person that has changed your civil status, and you are operating as one of the an officer, employee, agent of, custodial entity handling public funds known as Federal Reserve notes, and put money into a bank account, a federally FDIC insured account. So we'll talk a little bit about challenging jurisdiction. That's what we're going to be doing. That's the very first thing that we will be doing. In fact, we don't have to wait for a criminal action or civil action even to start challenging jurisdiction. And that's part of the process we're going to be talking about, and showing people, teaching people how to start to do that properly, how to get your status properly notified or properly published into the public record, that you can then utilize it. So, but as part of that, we have to start understanding, today we're just going to focus kind of on the Federal Legislative Act that supposedly makes a possession and use of these certain controlled substances, cannabis and whatnot, a federal violation, prosecutable under Title 18. They also tie it to the revenue laws. But so we need to understand, and I talked about this briefly, but the underlying principle of legislative jurisdiction for the way the United States of America, United States is set up, Congress, when they're enacting legislation which affects the several states of the Union states, and the population at large, they cannot exceed the authority that's delegated to them in Article 1, Section 8, the Enumerated Powers Clause. Now, there are those two other jurisdictions. One comes under Article 1, Section 8, Clause 17, the exclusive legislative authority for the District of Columbia, territories, or the forts, magazines, territories. And then also under Article 4, Section 3, Clause 2. They have the permission to do those things for the federal territories, property of the United States. And then also as pertains to the operation of the United States government itself. So, but what makes it very easy for us then is to understand also, we just have to go look at their own rule books, the own things that they've said, the United States Code, the Administrative Procedure Act, primarily, number 1, and the U.S. Code 44 U.S.C. 1501. Both of those are the Administrative Procedure Act and the Federal Register Act require publication, irrespective of actual notice to you personally, individually, as a prerequisite to issuance of a regulation making certain acts criminal. Now, that's a holding by the United States Supreme Court, 1954, in Hotch v. U.S. Okay? So that's all we need to know. If it's not published in the Federal Register, it doesn't have applicability to you and I, the general population at large, out here in the states of the Union. Places that you think that you're at. Utah, California, Nevada, as the organic republic that's federated together with the rest of them to create the United States of America. You know, so one of the very first things, glaring omission, is that there are no regulations for Title 18 in the United States Code. Now, they've got stuff stashed all over the place, but therefore, by the terms of the Federal Register Act and the Administrative Procedure Act we just talked about, there can only be 3 applications of penalty statutes classified in Title 18. They have to apply to agencies and officers, employees and agents of the United States. They can apply in the territories and insular possessions of the United States, and also in the areas where the United States have admiralty and maritime jurisdiction. Now notice, those are all jurisdictions and applications that are special in nature. They're not generally applicable. Okay? So, the authority to regulate government, define and punish piracy and other offenses on the high seas, those are Article 1, Section 8, delegated powers. And the special territorial jurisdiction of admiralty and maritime, that falls into Article 4, Section 3, Clause 2, municipal authority, and also comes under Article 3. It talks about the types of law, at law, equity, maritime, and admiralty. Those are the jurisdictions. Those are the only forms of law that have applicability to the general population. And the admiralty and maritime are very special, restricted jurisdictions that apply specifically in certain areas. But we're not going to get into that too much. I'm getting off track just a little bit already. So now we understand that nothing listed in, it has to be put into the Federal Register, according to the Federal Register Act 44, USC 1501. So let's take a look and see if the federal drug control laws, which were first framed in Public Law 91-513, Title II, Section 101, on the 27th of October, 1970. It's 84 Statute 1242. Now, those are all just part of the codex and the indexing system. You're going to find these things, but primarily looking at Public Law 91-513. And in the United States Code, you'll find it at 21 USC 801. Congressional findings and declarations, controlled substances. Now there's a whole list of findings and declarations about how awful it is and it's terrible and we can do it because of interstate commerce and blah, 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 blah. Okay? Problem is that that's not there in federal registers. We're going to go through here in just a second, but I think it's important to understand, okay? You need to start asking yourself all times, does the Constitution for the United States of America, does the Constitution for the United States, both of those in 1787 and 1789, the one that everybody believes that you have, that provides you all those wonderful protections, is that still in force? Is it still valid? Does it apply to you? Or has it somehow been removed in some kind of way or diminished? The areas that it's applying to are less somehow than what they are stated specifically in that document to be. we've talked a little bit about the fact that it appears that the states, the incorporated state of, are operating as political subdivisions, associations under the federal territory authority of Congress, Article 4. But that can't possibly be if we understand how the Constitution really applies, how it works. And we can go to a very famous case, most people are familiar with it, Marbury v. Madison, 1803. Chief Justice John Marshall talk about that very issue of what happens when, if the Constitution's been in place, can it be removed? So I'll just read these words, a couple paragraphs, so just bear with me. But the question is whether an act repugnant to the Constitution can become the law of the land is a question deeply interesting to the United States, but happily not of an intricacy proportioned to its interest. Seems only necessary to recognize certain principles supposed to have been long and well established to decide it. That the people have an original right to establish for the future government such principles as, in their opinion, shall most conduce to their happiness, is the basis on which the whole American fabric has been erected. The exercise of this original right is a very great exertion, nor ought it to be frequently repeated. The principles, therefore, so established are deemed fundamental, and as the authority from which they proceed is supreme and can seldom act, they are designed to be permanent. This original and supreme will organizes the government and assigns to different departments their respective powers. It may either stop here or establish certain limits not to be transcended by those departments. The government of the United States is of the latter description. The powers of the legislature are defined and limited, and those limits may not be mistaken or forgotten. The Constitution is written. To what purpose are powers limited, and to what purpose is that limitation committed to writing, if these limits may, at any time, be passed by those intended to be restrained? The distinction between a government with limited and unlimited powers is abolished, if those limits do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by an ordinary act. Between these alternatives, there is no middle ground. The Constitution is either a superior, paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts, is alterable when the legislature shall please to alter it. If the former part of the alternative be true, then a legislative act contrary to the Constitution is not law. If the latter part be true, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature illimitable. Certainly all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. Well, we look at those congressional findings, declarations, and the Controlled Substance Act, 21 U.S.C. 801. Okay? Seems like that's possible, falls within their realm of things, to be able to interstate commerce, treaties, international treaties, and so on and so forth. Okay? Well, Congress or the president, doesn't matter how many treaties, accords, conventions, well, the application of those has not been delegated by enumerated power, delegated authority, doesn't matter. You know, they say that treaties, the law of the land, but doesn't give them that permission. I'm talking about the treaties that were existing already in previously at that particular time, and it has to be done the same way too. Must be published in the Federal Register to have applicability to the general population. Okay? They can't get around that rule ever. If it applies to me as a man walking around out here that I know who I am, I'm not an agent, employee, a custodian in the United States. I'm a sovereign lawful authority walking around that the government gets its authority to operate from. If it's not in that book, Federal Register, it doesn't apply to me, period. Cannot be made to apply to me, period. So, unless and until there's a constitutional amendment delegating regulatory authority pertaining to commodities, federal regulatory authority doesn't exist out here in the States. Can't. Okay? Now, talking about interstate and foreign commerce, if that was the case, then what's the point of having state and local sovereignty? Can't have it. They'll be doing what? Writing bills of attainder, which is prohibited Article 1, Article 9.3, and then Article 1, Section 9, Clause 3, and then Article 1, Section 10, Clause 1. They'll be, the federal government would then be writing bills of attainder for the states. Cuts right through the understanding of sovereignty. Articles of Confederation talk about those 13 individual sovereign states, and their sovereignty shall not be diminished. Articles of Confederation is a perpetual document. We talk about also Article or Amendment 11, state sovereignty. Okay? So, let's take a look at 21 U.S.C. 801. Now, there's another book called the Code of Federal Regulations. There's also a parallel table of authorities and rules in the book. I'll explain more what those are, how to use them. But if we're looking at that, the regulation list, the only regulation we can find that's listed for 21 U.S.C. 801, which is the supposedly Controlled Substance Act, is that 21 CFR Section 5. And that relates to delegation of authority and organization of Food and Drug Administration, Department of Human Services. So the underlying authority, Public Law 91-513, also has a regulation at 42 CFR 2A, and that prescribes regulations for protection of the identity of research subjects. And that regulation happens to be one of the only ones surviving of the Comprehensive Drug Abuse Prevention and Control Act of 1970. Okay? Now, Public Law 91-513 has been amended a bunch of times. Been amended a bunch of times since some of this information came out, so we're going to be looking at that a lot closer in the book. Okay? The problem is that there aren't any. Most of the laws stuff doesn't apply to you and I. There's no implementing regulations, and if it is, it goes to personnel, goes to departments, goes to foreign relations, records keeping, okay? Once again, keeping in mind too then, though, that those very things, Public Law 91-513, 21 U.S.C. 801 can be applied in its entirety to who? Employees, agents, custodians, people living in the actual territories subject to the United States. They're people. And they have tried to convert you into one of their people through this mechanism right here. Federal Reserve notes. Talked about that before also. Okay. Bank acts aren't in the Federal Register either. Okay. Those apply to specific special applications, specialty groups. specific special jurisdictional territories. Okay? So the problem is that there's a whole bunch of statutory and regulatory listings all over the place tied into these various things, 21 CFR. They do not have application, general applicability, criminal enforcement authority in the Union States, except as they might pertain to somebody involved or importing in and out of the geographical territorial area of the United States, possibly, but that vests authority in the Coast Guard. Territorial waters, maritime, admiralty. You know, one of the issues you have to look at is the Attorney General. They have enforcement for certain things. As far as his application for the, well, he has control over the Department of Justice, which then also controls the Drug Enforcement Administration, DEA. You can find some of those that delegated authority, statutory authority for the Attorney General for enforcement, 28 U.S.C. 535. And that's limited to investigation of officers and employees of United States government. Now, the thing that most people don't understand, too, is your Drug Enforcement Administration, the DEA, one that comes in, kicks everybody's door, comes into your place of business when you're in one of those dispensaries in those states that have medicinal cannabis laws in place. Those guys come in with a mask on. Yeah, because they're criminals. They don't have jurisdictional authority to be doing the shit they're doing to you people. None. Anyways, that agency, administration, was created by in the Presidential Reorganization Plan, not by Congress. Okay, it's under executive orders. Guess what? It's not published either. Federal Register. Okay? It's not complicated, people. This is simple stuff if we learn how to read and apply it to ourselves, our situations, which we're going to be talking about how to do that. But what we're going to be doing then. Now, talk a little bit about Coast Guard. United States Customs Service is also administrative creation. And it's different than the one that was originally created by Congress way back in the day, subject to their Article 4, 3.2 legislative jurisdiction. But even then, it doesn't apply to the several states, the Union States, part of the Constitution. Your import and export licensing requirements apply Puerto Rico, Guam, Virgin Islands, American Samoa, the Northern Mariana Islands, District of Columbia, possibly. Well, we're looking at Title 21 also. There's things in there about drug abuse prevention and control, contained somewhere, at some point, Chapter 13. When we look at the definitions located at 21 U.S.C. 802, Control and Enforcement, Part A, Introductory Provisions, the critical definitions are at 21 U.S.C. 802, 26 and 802.28. Those are definition number 26, which is the term state, means any state, territory, or possession of the United States, the District of Columbia, Commonwealth of Puerto Rico, the Trust Territory of the Pacific Islands, and the Canal Zone. Now, the Canal Zone, that's been removed, but anyways, the next one's 28. The term United States, when used in a geographical sense, means all places and waters, continental and insular, subject to the jurisdiction of the United States. Okay? Your state, my state, Utah, is not a state of the United States. They're states of the Union. Okay? Talks about it right there. Okay? Article 4. No other state, other states may be brought into this union. Okay? They're independent nation states. They have legislative autonomy, supposed to be. Sovereignty. But Now, we've gone into this before, and it goes into a lot more extensively in the book about the definition of states, what that means, how it's the definitive, the rules of inclusion, including the rule of the inclusion of ones, the exclusion of all else. Anyways, we make it's standard statutory construction law, an understanding, and that a state doesn't include all those. It's geographic United States. So, bottom line is that in order for criminal liability to attach, that law has to be published in the Federal Register. The regulations have to be published into the Federal Register. Not published in the Federal Register, not published in Code of Federal Regulations. Guess what? It doesn't apply to you. It applies only in those specific areas that we've already talked about. Employees and agents, the United States, those territorial areas of the United States. That's it. No. This is a very cursory review. Now, understand, if you're going to be going up against this regime, this criminal organization, the most violent, the most dishonorable group of individuals ever to roam this planet, you had better be prepared to start doing some reading, some studying, get a true understanding of these concepts, these rules of statutory construction. Now, I'm putting out here pretty simple, but it pretty much is that simple. Okay? There are some things you have to read. It gets a little bit heavy on some of the things, but we have to understand these things. But the number one thing you've got to understand is the Constitution of the United States of America, the Constitution of the United States, 1787, 1789, apply to the Union States. The Union States cannot have been removed, cannot have been changed. The application of the Constitution cannot be removed from them. The fact that your states are operating as political associations, pretending to be under the territorial authority of Congress and its Article 4 authority, is absolute nonsense. Now, you can join any political association you want to. You can. And by joining that political association, you then are bound by the rules, regulations, the contract for that political association. But it must have been done voluntarily with full knowledge and consent, which is what has happened. Now, the Constitution is the supreme law of the land. That's what everybody says. And it is that because it attaches to the land. Your state of, wherever that happens to be, is a fiction that has been overlaid, the rail land, the dirt. Okay? It's a club. It's a employer. It's like working for a company. It's like joining a political party. And the fact that they have forced everyone to use Federal Reserve notes, the fact that they have forced everyone to take a number, or at least believe that that number belongs to you, because it does not. The fact that they have lied, the fact that they have, in violation of the contract known as the Constitution, they are in open rebellion, open war. They are treasonous. They have engaged in war against the states. That's the only definition of treason. The fact that they're pretending to be a government under color of law, de facto under force and violence, doesn't change the fact that that Constitution protects me. I can call upon it at any time. even in your so-called private courts of the United States, district courts, which is private, non-constitutional, so-called legislative, administrative courts, don't have proper constitutional jurisdictional authority. When we look at the rules of federal criminal procedure, Rule 54C talks about what? An act of Congress, I'm pretty sure what we just read was an act of Congress, Controlled Substance Act, okay? Includes any act of Congress locally applicable to and enforced in the District of Columbia, in Puerto Rico, in a territory, or in an insular possession. Okay? Now, another thing too, very interesting, that the United States Supreme Court, everybody believes is so high and mighty, and they are too in their area, is a creation of Congress. Article 1, Section 8, Clause 10, Book Law of Nations, Book 1, Section 165, creates your Supreme Court. They also created it in the Judicial Act of 1789. Okay? They are not an Article 3 court. If you read your Constitution, read it. What does it say in Article 1? Legislative power herein granted shall be vested. Article 2, executive power shall be vested in the President of the United States of America under the Articles of Confederation. And Article 3, the only one that didn't have any power. Judicial power shall be vested in a Supreme Court and other inferior courts as Congress may from time to time create. Judiciary Act 1789, Congress created. Legislatively creative. And I know this for a fact, and you can prove it for yourself. Congress then gave, at some point, not too long ago, well quite a ways, long time ago, permission to the Supreme Court to write rules and regulations that affect legislative acts. Now, let's see if I can find it here. Let's see here. Anyways, that's important to understand. When you understand your three branches of government, the separation of power, the legislative branch can in no way act as the judicial branch or the executive branch, or encroach upon their authority and power. Can't make rules and regulations for the judiciary. They can do their own, but they can't. The judiciary can't do it for the legislature. Same thing with the executive. They have got to be specifically separated. So how is it possible then that I gotta find this because this is really important. That the fact of not that one, sorry. Fact that Congress gave authority to the United States Supreme Court under Article 1 to make rules and regulations. What the rule regulation says that anything that applies or anything that is in conflict with the rules, any statutes that's in conflict with the rules is automatically repealed. What that means is that if Congress, writing a legislative act, writes a statute, and it's in conflict with the rules promulgated by the Supreme Court, that statute is automatically repealed. Doesn't go through the proper process. And due process applies to written legislation. Also has to go through the proper process. It can't just be automatically repealed. But we can use that for our advantage when we start understanding these things. And we talk about how the fact that under that premise and under Rule 54C, an act of Congress, any act of Congress, has to apply to where? What we just said. that any act of Congress includes is only locally applicable to and enforced in the District of Columbia and Puerto Rico and a territory and insular possession, period. Anything that says is an act of Congress, unless it is regulations and published in the Federal Register, not generally applicable. Title 18, not in the Federal Register, not generally applicable. Your United States District Courts, the only place that they've been given any authority by Congress is in the Civil RICO Act for civil injunctive relief, period. They don't have criminal prosecution authority. They don't have subject matter jurisdiction. They don't have territorial authority jurisdiction. They don't have in personam jurisdiction over you at all. Unless you're there for a civil RICO matter and they're acting in a capacity to provide civil injunctive relief. That's it. Or you are what? A person, an employee, an agent, a custodian, or you're actually in one of the real territories or insular possessions of the United States. Or you voluntarily choose to be a United States citizen. So, I'm going to end that for today. I know it might be a little bit crooked, or a little bit kind of meandering around like I do, but these things are important, people. It's not that complicated. If it's a law that applies to you at the federal level, it has to be published in the Federal Register, period. End of story. Not there, doesn't apply to you. Your states cannot get out of their constitutional contract. They're being bound to the Constitution of the United States of America, the Constitution of the United States, and what it says about making nothing but gold and silver payment of debt. They don't have permission to write uniform acts. They don't have permission to bring any form of law to bear upon the members of their society other than at law, equity, admiralty, or maritime, period. Civil law doesn't apply. Cannot. They're in violation. They're in violation of their known duty to protect you and I from foreign invasion. The United States of America, are foreign government entities, foreign to the state of Utah, or the organic state, the organic Republic of Utah. And certainly how they're operating now. The fact that my state allows federal agents of any kind to come here and violate me, kidnap you, your friends, your loved ones, kicking your door, property damage, applying laws that don't have general applicability. Now, I suppose they can do that if they're coming to get you and you're one of their people, but I'm not one of their people. I'm not a United States citizen. And the fact that I've been forced to use Federal Reserve notes, I've been forced, a number forced upon me, my right of necessity, my right of self-preservation, my right of being able to have to defend myself after I have been abandoned by my sovereignty. My state sovereigns have abandoned me, and we'll talk about that in one of these other videos. It's also in the book too. It's in the book Law of Nations. Talks about what happens when the sovereign abandons his people. They're no longer bound to him either. Okay? So it's happened. That's the power of this book, Law of Nations. You need to read it. And like I said, you need to read my book, Constitutional Cannabis, when it comes out, but it explains these things a lot better. But it's not that complicated, people. 44 U.S.C. 1501, every document which prescribes a penalty or law of general applicability and legal effect must be published in the Federal Register. Period. Not there, guess what? Doesn't apply to you. Unless you're in one of those special areas. Territories or insular possessions, you work for the government, or you're a United States citizen. So, this has a huge impact also on the taxing provisions, on pretty much everything. Okay? start peeling back the layers and find out you are being operated, your country is being run by a criminal organization. They don't even obey their own rules and regulations, but they do it all by force. Huh? So, anyways, I said, I pledge to you my life, my fortune, my sacred honor to continue to try to get this information out, do a better job, finish up this book, helping people understand what's going on and how unlawful what's going on right now is. Okay? How criminal your governmental officials are acting complicit with another organization. And if you don't think that your elected officials, your state attorney generals, your governor, your members of your legislative body don't know this information, well, then they shouldn't be in those positions. And if they do, then we have to ask the question of what is with you guys? Why are you lying to us the way that you are? Why have you allowed this to happen? Are they threatening your families too? Like they've threatened mine, threatened me? Okay? I understand, but some people, sorry, you're going to have to start taking one for the team. And pretty much the only way to save your families, if you're in that position, you know this information, but you're afraid to speak out, is you have to speak out. That's the only way we're going to be able to stop this murderous criminal regime. Okay? If everything everybody says they claim about the Constitution of the United States is so great, best form of government ever, okay? And why aren't we living by that? Why aren't we living by the rule of law? Why are elected officials allowing us to be lied to? Why are they lying to us? Now you can research all this stuff for yourself. You better verify it. Okay? Not published in the Federal Register, doesn't have general applicability to the general population out in these states of the Union. Period. Okay? So I can start challenging your subject, your jurisdictional authority. And that's what we're going to be talking about next, for the next little while, about how to do that, how to put notices in the in your local county recorder, makes it public information, designates what your true political will is, what your true status is, the fact that you know who and what you are, and that you, understanding that you are the lawful sovereign authority that government operates upon. And they have violated their known duties to you and your family through all kinds of things. But we tie all those things back to the laws which are superior even to your Constitution, the law of nation, which is the law of nature, is applied to sovereigns and sovereignty. If we go to Book 1, Section 1, explains specifically what the sovereignty is, which is the organization, the form of government, the offices, and the sovereigns then are the members of society that sit inside and operate, exercise the sovereign authority, your sovereign authority, for the mutual safety and benefit of the entire society, not just a small group, which is what's happening right now. So, love everybody. Welcome to 2017. It's going to be a great year. And like I said, I'm going to finish up this book, try to do a better job on these videos. Got some people helping me, hopefully. We're making a new set. Make it more like, infotainment, I think is what my son Jason called it. He hates it. I do too. But that's what we have to do to get people even stop long enough to even get through the noise of society, try to get people to understand these things. Okay? There's ways people, you can get your loved ones that have been kidnapped by this criminal group out of federal prison. Okay? Start challenging the authority that these people claim to be operating on, because they don't have any. And it's easy to verify, easy to prove that they do not. They're using their own rules and regulations. Simple reading, common sense, basic logic. Now, the problem we're going to have is that a lot of people sitting in the positions of authority that should be helping us aren't, won't, refuse to, stand silent. Well, by their silence, on these issues which they have a legal duty to answer. They are confirming them. They're confessing the truth of what we're saying. Now it's just a matter of getting enough people educated on these simple concepts, looking at the simple truth, and start liberating ourselves, our families, those that have been improperly kidnapped, improperly prosecuted, had their liberties stolen from them, and you start understanding about the fact of jurisdiction. If it's not there, doesn't have proper jurisdiction, those agents of government are operating as private individuals or don't have sovereign immunity, don't have immunity of their offices. And they could be prosecuted and they can be charged, they can be sued civilly for damages. That's what we're going to start doing. We're going to have to. So, love everybody and have a good day. Wow, 45 minutes.